I have one matter I'd like to raise to the court.
Yes.
I was reviewing and kind of going over the testimony yesterday, and I would like to make a motion for a direct verdict on count one. Looking over the testimony of the different officers, no officer testified that they measured the length of the blade, and there is an insufficiency of the evidence gap for.
All right, pause right here. This is a classic defense move. A motion for a directed verdict means the defense is basically saying, even if everything the jury heard is true, the prosecution still didn't prove the case. And the entire fight comes down to one thing. Did anyone actually measure the knife? Spoiler alert, that's about to matter a lot.
The elements to meet the city ordinance regarding the length of the blade. Sergeant Mueller, at best, testified that he estimated it to be over 6 inches. My client said that when she was on the stand, that she didn't think it was over 3 inches, and the officer who actually bagged it into evidence was Officer Shading, and he offered no testimony as to measuring the length of the blade before the close of the proofs. And so, pursuant, Your Honor, to People versus Wolf and People versus Hampton, those are kind of the two guiding case law on city evidence. And then there's also the case of People versus Parker, which established the state analog for the dangerous knife statute. Court of Appeals held that that is a mandatory element of the length of the blade has to be.
This is where legal nerds perk up. The defense isn't arguing vibes or opinions. They're arguing elements of the crime. When a statute says over 3 inches, courts usually want proof, not guesses. Question for you. Should estimating ever be enough when freedom is on the line? Drop your thoughts below.
Established by evidence at trial.
Your Honor, in response, I would say, first, I believe this motion may be late and should have been taken up at a time before the defense put on their case and closing arguments were given and the jury was given instructions. That aside, I believe Officer Mueller did give enough testimony. There is not a element of this charge that Mr. Mueller has to bring out a ruler and measure the knife. He can have the ability as a person who has been a police officer for, I can't remember how long he's been on the force for quite a time. He's dealt with these charges before. Also, just as a general person who can use their general knowledge, can look at something and tell if it's over 3 inches.
So I can't look at something and tell if it's over 3 inches by looking at it. It could be 1 inch less. It could be a 1/4 inch less. It could be an 8.
And here comes the prosecution's gamble. Trust the officer's experience. But experience isn't a measuring tape. This is the courtroom equivalent of saying, I eyeballed it. Would you accept that logic if it were your case?
Of an inch less, and it would make the facts insufficient. There is an officer that doesn't have a training in estimating the inch of a knife. What training is that?
He does not have training to tell the exact measurement of a knife, but
he estimated to be over 3 inches, but he couldn't give us the exact length of the knife, and the elements are clear. It has to be a blade over 3 inches.
But there has been evidence presented to the jury, including visual representation of that knife, that they can make a determination on their own whether or not they believe that knife is over 3 inches or not. They don't have doesn't have to be evidence presented.
It's not the duty of the jury to make an estimation about how long a knife is by looking at a video.
It's not their duty, but they have the ability to analyze the evidence that's been presented to them. They
You can't pass your duty to the jury. It was the people's duty to present information to support each element during their case in chief. You called 3 witnesses. You played video, and nobody ever brought out evidence about how long that knife actually, or that blade actually was. There wasn't even any real inventory information as to what was in the bag. The people were well aware that there was a potential defense, if that's what we call it, that there were other items that were going to be in the bag. Some testimony about a missing check, but some spoons and other silverware. I think there was a question, I think it was on cross, about who would have inventoried the bag. There's no evidence that the contents of that bag was ever inventoried, that they ever took that knife and actually measured it. There was no picture of the knife. There's a video, and you want me to say that because the people, the jury saw the video, that they can estimate what or the length of that is, and that it's over 3 inches?
No, that's not what I am saying is the evidence that was presented in front of them, including testimony of the officer who says he believes that knife was over 3 inches, in conjunction with the video where they can at least see it. They don't know what the exact length of that knife is, but they have the ability to believe, I don't think that's 3 inches.
I have the ability, she has the ability to believe she's a millionaire. I think I heard that on the video. Does that make it true?
No, but that gives the jury the ability to decide on their own if they decide the fact is true or not. They are the trier of fact.
That's not, no, you have to present evidence first. And the motion is that there's been insufficient evidence to even put it before a jury. And I agree. There has not been any information put forth by the people that would establish with any reasonable certainty that this knife was over 3 inches. There's a kitchen knife, which I saw briefly pulled out of a bag on the video. The jury saw the same thing. There was never testimony, did you measure the knife? That's normal question for the prosecution to ask their witness if you're going to charge someone for having something above the legal.
This is the moment that changes everything. The judge just made the DUI comparison because courts require exact measurements for blood alcohol levels. The implication is brutal. If we wouldn't guess a BAC, why guess a blade length? That's a devastating analogy for the prosecution.
Limit as it relates to the inches here. Give it an example. Do you think that we can just let people get drunk driving and we estimate that their blood alcohol level is above a 0.08, or do we actually have to measure it?
But they can be arrested based on their.
But can you put it to a jury based on, I estimate that their blood alcohol level was above a 0.08, or is there a requirement that the people put forth some evidence that shows some measurement?
I think
you don't want to answer that question.
I think we're.
You answer the question first, and then I'll let you get
we don't put an estimation of a intoxication in front of a jury without any other evidence. But I believe Officer.
No, it's measured. Right. It is measured because there's a requirement that some measurement show that it's above the legal limit, so you can bring it to the jury. We can't just arbitrarily put information before the jury for them to try to sift through and make their own determination. That is the whole purpose of the motion for direct verdict. That's why there is that opportunity available to the defense, so that if the prosecution has not met their burden to bring sufficient evidence to even bring to a jury, that we don't leave it to a jury to try to sift through and make up the evidence on their own. That's not appropriate. It's prejudicial. And it was clearly the element was only that it was a knife above 3 inches. All you had to establish was that it was above 3 inches, and that was never established.
What I would like to say is, Your Honor, I believe that, and I don't have the case law in front of me. I believe only a scintilla of evidence to that element has to be presented to the jury.
Based on what case law are you?
And I don't have it in front of me.
It doesn't have to be only a scintilla of evidence. You have to prove that beyond a reasonable doubt.
That's for them to
the element that you have to prove beyond a reasonable doubt is that the knife was above 3 inches.
But it does not have to be proved beyond a reasonable doubt just to get to the jury. That's for
no,
them to
that's decide. You have to put evidence before the court, before the jury, that sufficient enough for them to make that determination. You've not put anything on this record to tell if this knife was 6 inches or if it was 2.5.
I believe Officer Mueller was asked directly, do you believe how long was that knife? And his testimony was it was 5 or 6 inches.
No, he approximated it to be 5.
That's the evidence that was put forward to the jury, and it's for them to decide whether they want to believe some, all, or none of what that
an
witness
approx,
said.
no, because because if it's a motion that is insufficient, now it's my duty to respond as to whether or not that was sufficient enough to put to the jury. I do not believe that giving an approximation where the element is to be exact, that that it's above 3 inches, that I looked at it, nobody testified as to, or a question that witness as to whether or not he was trained to estimate length of a foot. We don't know anything about that. I don't know anything about this officer and his ability to guesstimate how long a knife is. I don't even think that guesstimating the inch is reasonable under the circumstances if you're going to charge someone with a knife over 3 inches.
This is judicial reality check time. The judge isn't saying the officer lied. He's saying the law requires precision. No ruler, no measurement, no inventory photo, and suddenly this entire charge is hanging by a thread.
And you're going to pull out something to measure it.
Your Honor, I would ask for the ability to brief this if the court doesn't want to allow that.
I'm going to take the motion under advisement anyways, because we've already I've already given final instructions and told the jury that there were 2 cases that they'll be deciding for. I do agree that you dropped the ball by not making the motion when you should have been making the motion before you gave your case after the.
I agree. I agree, Your Honor, that I should have made the motion to the close of prosecution's proof. I believe that under the rules, I still would have had the opportunity at the close of our proofs that I could have raised it at that point as well. But I recognize I raised it at neither point. The jury's been set out. It would almost be like a JNOV at this point. That if the verdict does come back, I would ask that be dismissed as a matter of law pursuant to this issue. But
I will allow the parties to make or to brief the issue if necessary after the jury makes their decision.
thank you, Your Honor.
Okay, my understanding is that you do have a verdict. Is that correct? Who's the 4th person? If you can stand and read your verdict.
Sure. On count 1, knife with over 3 inches.
Wow, guilty despite all that. And this is where people get confused. A verdict doesn't always mean the case is over. That pending directed verdict motion, it's basically a legal safety net that could still wipe this conviction out. So here's the real question. Should juries decide facts when the evidence itself might legally fall short?
Find the defendant guilty. And on count 2, hinder, oppose, resist, obstruct, to find the defendant not guilty.
You want the jury poll. Juror number 1, is that your complete and accurate verdict?
That's mine.
Juror number 2, is that your verdict?
Yes.
Number 3, is that your verdict? Number 4, is that your verdict?
Yes.
I think we released number 5, is that correct? Juror number 6, is that your verdict? Your juror number 6.
Yes.
Juror number 7, is that your verdict? Yes. Thank you. I want to thank you all for your participation and for appearing, even though it spilled over into the second day. Also for bearing with us with the temperature issues we have in here. It's a little bit better this morning than it was yesterday, but being attentive and taking your time to do your due diligence while in the jury room is the only way the system for justice can work. So I appreciate you appearing today. I believe this will conclude your jury service for this week because we don't have any trials here on Thursday or Friday. So thank you again. You'll be exported out to administration and then you need to receive your payment for today as well. All right. Okay, so there was a guilty on count 1, not guilty on count 2. Of course, it would be the count that we have a directed verdict pending on. So I will set this for a motion hearing. How much time do you need to brief your motions?
Your Honor, I don't know that I need a ton of time, but I am going out of town from the 26th until the 7th.
1:30.
1:30 on the 15th. Thank you, Your Honor.
Sounds good.
And I don't know, does the court require a PSI? If there were to be, if the motion were to.
I'm not setting it for sentencing yet.
Until
so,
that.
yeah.
Very good, Your Honor.
Any additional matters for today's record?
None from the city, Your Honor.
None from the defense, Your Honor. I appreciate the court's time.
I do have one. There's a City of Lansing versus Ms. Tyson 24L2882601. It's just to show cause because you owe $186.
Yes, Your Honor, Ms. Tyson is aware of that. I did kind of tell her to put that on the back burner while we were dealing with this, but she is aware.
Back
of
burner,
that.
she's a millionaire. She's paying that today, isn't she?
I don't have it yet.
No, no, you said, see about you, I saw the video. You said you were a millionaire. You had a couple books
In my
coming through.
mind.
Oh, okay, got it, you're speaking it into existence,
Yes.
okay. Well, when do you think that your millions will manifest so that you can pay this 186?
Hopefully sooner than later.
How long should the judge put the due date?
And you can make payments, you don't have to pay it all at once.
Okay, so if you can give me about 30 days,
And how much are you gonna pay in 30 days?
it's 164,
186.
186. We can do 50, and,
Maybe 50 a month for 4 months?
But you'll pay $50 within 30 days and you'll pay $50 per month until paid in full.
Okay.
You're all set.